Good morning, everyone. Good afternoon, good evening from whichever part of the world you are joining. My name is Surya Dev. I am a professor at the Macquarie Law School and the director of the Macquarie University Environmental Law Research Center. It gives me a great pleasure to moderate this discussion on climate change and human rights, the advice from advisory opinions. At the outset, I would like to acknowledge the traditional custodians of this Macquarie University land, the Walamatukal clan of the Darug Nation, whose cultures and customs have nurtured this land for centuries. And I also pay my respect to elders past, present, and emerging. Human rights are not merely negatively impacted by climate change, but human rights also offer a powerful tool to articulate the obligations of states and businesses in relation to climate change. And the three advisory opinions in recent times have articulated these obligations very clearly. There's a lot to discuss, but today's webinar is going to focus only on one key aspect, which is the intersection between climate change and international human rights law. And we have a very distinguished group of panelists joining this discussion with me. So let me briefly introduce all the panelists in one go, and then we will jump into the discussion. With us, we have Justice Brian Preston, who is a Chief Judge, Land and the Environment Court of New South Wales. And he is a leading authority, not merely as a judge, but also he writes quite a lot in this particular field, and he is known all over the world for his work. Then we have Dr. Jolene Lin, who is an associate professor at the Faculty of Law, National University of Singapore. And she also published recently her book on climate litigation. So we'll know more about that very shortly. Then we're also joined by Professor Carlos Bernal Pulidio, my colleague at the Macquarie Law School part-time, but more importantly, for today's purpose, he's also the commissioner of Inter-American Commission on Human Rights. Then we have Ms. Joanna Guzman. She is a senior lawyer at the Center for International Environmental Law, and she has played a key role in mobilizing this advisory opinion, especially of the ICJ. She will tell more about that. Last but not least, we have Ms. Heike Ellefson. She is the regional representative of the Office of the High Commissioner for Human Rights, Regional Pacific Office. And this webinar is co-organized by the Macquarie University Environmental Law Research Center and the Office of the High Commissioner for Human Rights, Regional Pacific Office. So it's really a great pleasure for us to do it together. Now, the format of this webinar will be like this, that I'm going to ask some questions to the panelists. And then I will encourage all the participants to post questions in Q&A button at the bottom of your screen. And I very much hope to pick some questions, and it's more like a conversation, and I would like to weave all of you in this conversation together. This webinar is getting recorded because we received requests from a lot of participants. They want to listen to this recording because not everyone is able to join. So I hope that is fine with everyone. So with these remarks, Carlos, if I may start with you. So what do you make out of this advisory opinion of the Inter-American Court of Human Rights, especially because the court articulated both substantive and the procedural aspects of human rights to articulate the obligations of states? Carlos, you have the floor. Thank you.
Thank you so much, Surya. This is a great pleasure and an honor for me to participate in this webinar. Look, the opinion has more than 250 pages, and I'm going to try to summarize in 3 minutes in 14 points, the 14 most important points of the advisory opinion. The first point is that there was a wonderful, wide and participatory process in which we had 293 amicus curiae and 185 presentations in hearings. So this raised the discussion concerning climate change and the climate emergency in the whole continent. Second point, the court basically framed 3 issues which can be summarized in the following way. Given the climate emergency, what are the obligations of the states concerning, first, substantive rights, in which the court included the right to life, health, environment, personal integrity, family, property, housing, water, food, work, social security, employment, education, and culture. Second point concerning procedural rights, particularly access to information, participation, and access to justice. And the third point concerning the right to equality and the protection of the most vulnerable, namely children, people who defend the environment, women, indigenous people, Afro-descendants, and farmers. My third point is that the court made a wonderful explanation for everyone about the international and then the inter-American and the domestic framework concerning the obligations of the states related to climate emergency. Fourth point, the court made a wonderful work also explaining the climate emergency and its effects. The fifth point is very controversial, namely that the court has a competence to interpret only the Inter-American Convention of Human Rights. That is to say, that in principle, the advisory opinion should be binding for the countries that has submitted to the jurisdiction of the Inter-American Court of Human Rights. However, the court made an amplified interpretation of that power in the sense that it says that all the countries that belong to the OAS, to the Organization of American States, and that have ratified the Declaration of Human Rights are binding. This is quite important because one of the most relevant countries in that list is the United States, that of course is a great contributor in the emission of greenhouse gases. The sixth point that I wanted to say is that in paragraph 210, the court tends to say that a key point concerning these, how to solve those questions, is the right to sustainable development. However, the court did not explain how to solve the tensions between, on the one hand, climate change mitigation, and on the other hand, the right to development. That's a question that is interesting and relevant for Surya. Now, the seventh point is that the court explains very clearly the obligation of the states concerning the guarantee that public and private powers work cohesively to mitigate the climate emergency and to articulate a duty to prevent according to the principles of precaution and prevention, and that everyone has a high duty of diligence or a high level of due diligence. The eighth point is that the way to fulfill this obligation is by means of a model of risk assessment, identification, assessment, and monitoring. The point number 9 is that the court talks about an obligation to guarantee the progressive realization of economic and social and cultural rights in the middle of the climate emergency. Now, in the point number 10, the court talks about the key substantive rights, and here there is an innovation, namely that the court attributes the idea of right holders to nature, to the ecosystem, and to the elements of the nature. This is a part in which there were dissenting opinions. Point number 11, and I'm approaching my end. The court says, and this is also very controversial, and there were dissenting opinions. The court says that there is the obligation of non-generating irreversible damages to the environment and to the climate is an obligation of jus cogens. Point number 12, that every country has to meet the mitigation targets, and that this implies the elimination, progressive elimination, but at the end of the day, elimination of fossil energies, livestock, and deforestation. Point number 13, that there must be a fulfillment of the corporations and businesses of the obligations also concerning climate change within the framework of business and human rights of the United Nations. And my final point is that the court makes a wonderful explanation concerning the procedural rights, how everyone has a right to science or climate science, including traditional and indigenous ecologic knowledge, access to information, enabling producing information, distributing information, facilitating access to information, political participation, access to justice, and the final right, which is very interesting, is the right to defend human rights. So this is like a summary of the whole of the whole advisory opinions in 14 points that can trigger this discussion.
Thank you very much, Carlos. Definitely, the advisory opinion of the Inter-American Court is path-breaking on multiple points, and I think we may need to organize 13, 14 webinars to unpack those points. So, but thank you for setting the scene so clearly and in a very precise time. Joanna, if I may move to you now, and because you're working with the Pacific governments as well as with the SPC very closely about the advisory opinion to the International Court of Justice. So from your perspective, and you are in Fiji now, so how does it feel on the ground? Because the Pacific led the whole movement which triggered the ICJ advisory opinion. Do the students and the governments and others, they feel vindicated but what ICJ decided?
Yes, it's a great question, and you can really feel immediately. I had the privilege of coming over with one of the Fijian ministers, and we were all hugging on the plane. It just felt so unreal. I mean, we were hoping for the best, but I think for many of us, we were absolutely surprised at how just incredible the advisory opinion turned out to be. And in terms of vindication, I think it's really more about, especially for the students, how many folks really were critical of their incredible campaign to bring this to the General Assembly and to have the International Court of Justice speak to this issue. And I think to have such a strong advisory opinion and to see such incredible leadership from this region, from the Pacific, really was so illuminating. I mean, almost at a loss of words at how happy so many of us are. I think one of the things, not to get it too far into all of the things, because there's so many of us here on the call, lots of friendly faces, a lot of folks know what went into this and just the extreme outcome of this. But one of the things that I want to highlight about the case is just how many firsts there were with this. Not only was it the most participatory ICJ case in its history, it was the first time we saw so many indigenous languages spoken inside the court. The first time we saw so many women being able to represent their own countries before the court. Folks who went against that sort of gate-kept ICJ space where we were able to not have just the big, powerful firms and fancy folks that got to represent people, but we made sure that it was countries who were able to represent themselves, that the folks that stood up had actually, the lived experience of what it means to be on the front lines of climate change and to speak with the conviction that comes with that. And to be able to kind of quell the naysayers and all of the critics and be able to have something as strong as we did come out of this, I think speaks to the legal strategy that went behind this to make this a case that would be different than what we have seen prior. And that sort of dedication to the real principles of self-determination, of human rights, of representation and inclusion was something that was really, really critical and important. And, you know, I give kudos to MSG and to SPC, who made sure to make space so that Cynthia and Vishal and the leaders of the Pacific Island students fighting climate change were able to address the judges themselves, that they were given the space to see full circle what they had dreamt of in that classroom 5 years ago, 6 years ago now. I think, you know, that was not only quite symbolic and representative and powerful, but really showed that so much of what went into this was youth-led, and that many of the states beyond the Pacific, you know, small and developing states in general, did well to make sure that that future generations and intergenerational equity piece was actually visible, you know, for the judges. And I think that truly made a difference. So yes, we're celebrating immensely over here, and as you can see, quite excited about the outcome.
Thank you very much, Joanna. You made several interesting points, but the one thing that stands out for me is that the world courts became people's court through this advisory opinion. I think that stands out. It's not a court 40,000 feet high up in the air. Rather, the court is trying to grapple with the real challenges. And of course, the gender justice issue is closely linked with climate justice. And I think that's why the role of the girls and women students who were fighting is very, very central. Thank you for that. So Brian, if I may come to you now, and as a judge, you have been grappling with some of these issues, both as a judge, as an academic, as a scholar, as a practitioner for a number of years. What stands out for you from the advisory opinion of the Inter-American Court of Human Rights in relation to either the obligation of states or the articulation of nature as a subject of rights? Over to you.
Let me deal with the aspect where there's a discussion of nature as being a subject of rights. The first thing I think I should say is that it's not clear in the reasoning whether the court is itself recognizing nature as a subject of rights, or it's merely noting that authoritative legal texts such as national constitutions and statutes do so, or that noting other judicial decisions of courts around the world which have recognized nature as being a subject of rights. I think on the better view, the court itself is not declaring that nature is a rights holder, but it does explain how the recognition of nature as the subject of rights can contribute, and this is its language, to a truly substantial development model that respects planetary boundaries and ensures the availability of natural resources for present and future generations, as well as protecting the ecological conditions that are essential for life and empowering local communities and Indigenous people who have historically been the guardians for ecosystems and possess deep knowledge about their functioning. So these are the words of the court. So it recognizes that there are benefits in recognizing nature as the holder of rights, but I think falls short of actually making that declaration. But how does it then get to that position where it recognizes, that nature could be the subject of rights? Well, I think although it's not made explicit, it would seem to derive from the correlative duty to protect nature. And the reasoning of the court, using their own reasoning, would seem to be as follows. First, it recognizes that the correlative, in Hofeld's sense, of the right to a healthy environment is a duty to protect that environment. Second proposition, it breaks this down. The right to a healthy environment protects components of the environment, such as the forests, rivers, and seas. Third proposition, the correlative duty must be to protect not only the environment as a whole, but also the components of the environment. Now, we come to whom is the duty owed. So the fourth proposition is the correlative duty to protect the environment as a whole, as well as its components, is owed, firstly, to individuals. They are the holders of the right to a healthy environment. But this is the important part. Secondly, that duty is owed to the components of nature, such as the forests, rivers, and seas. The fifth proposition, the obligation not to cause irreversible damage to the climate and the environment gives rise to a correlative right for the entities to which the obligation is owed. And this is what the court recognizes that other courts have found in recognizing nature and components of the environment as having legal personality and rights. So that is the route, I think, by which the court recognizes that nature, not just the object of rights, which is natural resources which are exploited, but also being the subject of rights. And as I said earlier, that gives rise to the benefits that the court sees in the protection of the environment.
Thank you, Brian, for trying to critically analyze the reasoning of the court and how the court has deduced that the nature could be a subject of rights. And of course, in the Latin America, there's a rich jurisprudence, both in the constitutional text, but also court decisions, where nature has been recognized as a holder of rights. But you can see that across the region. I mean, you can have those in New Zealand as well, right? There are examples there in Africa, in Asia as well. So I think it seems there's a growing interest on the rights of the nature. And the other issue which is linked is about the rights of future generations as well. And I think both courts talk about that. So let's see. So participants, I would also like you to involve. So there's a Q&A button at the bottom of your screen. So may I invite you to post questions in the Q&A button? And I'm going to pick some questions from there after Jolene finishes her intervention. So Jolene, thank you for waiting. Thanks for your patience. If I can come to you now. Now we have heard about the ICJ, what it ruled. We heard about what the Inter-American Court of Human Rights decided. How do you compare these two advisory opinions? Are you surprised on any aspect, especially in relation to the role of international human rights law? Because Joanna was hinting that they were not fully sure, because ICJ, and when it comes to human rights, it's not given that the ICJ advisory opinion is going to be path-breaking, right? But I think ICJ surprised many of us. At least it surprised me, if I could be honest. So I want to hear your reflections. Thank you.
Thank you, Surya. No, thank you for giving me the opportunity to listen to everyone before me. And so I wasn't waiting. I was really enjoying the fact that Carlos, for example, really set it out really well, the key points of this 200 pages opinion. And thank you also to Justice Preston for analyzing the legal structure that was taken in the opinion. And I was really recalling when Johanna was mentioning how excited and the students were when the ICJ was reading out the opinion 2 Thursdays ago. I think it feels like a whirlwind of events since then. I was involved in 2 different listening parties, and it was so exciting. There was so much jumping around and excited typing. It was because it was virtual, these listening parties, and yes, there was a lot of surprise as well at how the final AO of the trio of AOs really has been quite a boost to sort of the morale and to what is seen as what lies ahead for global climate action. So I'd like to answer your question by touching on 2 points that haven't been raised yet. So comparing the two advisory opinions in terms of the role and relevance of international human rights law to climate change obligations. So I've heard quite a lot of commentary that there might be a level of disappointment that the ICJ did not refer to international human rights law as much as they thought would have been appropriate. And of course, one compares that to the Inter-American Court of Human Rights advisory opinion. So I think that I'd like to put this comments in context. First of all, I think that obviously the Inter-American Court of Human Rights is a court of human rights, and it was taking the opportunity to really flesh out and elaborate the court's understanding and jurisprudence on human rights obligations and how that ties in with states' obligations to prevent and take accountability and be responsible and accountable for climate harm. While the ICJ, especially with the nature of the question that was posed by the General Assembly to the ICJ, it was asked in this chapter to actually to consider a wide range of sources of international law, and that includes, inter alia, international human rights law. So it wasn't it would have been inappropriate, I would say, for the ICJ to have just been dominantly focusing on one body of law. I do think also that the strength of the ICJ's opinion really was to reaffirm the centrality of the trio of climate treaties as the architecture for state cooperation. This has been faltering for quite some time, since 2015, when the Paris Agreement was ratified and came into force. Because there's this sense that, oh, the Kyoto Protocol has expired. That doesn't even mean anything. And the ICJ affirms this view that the state parties may not have agreed to a third commitment period after 2020. But that doesn't mean the Kyoto Protocol has expired. It remains part of the trio of treaties that are essential as the architecture for state cooperation. Now, when we look at the Inter-American Court of Human Rights opinion, what really struck me was the exposition on the difference between territory and jurisdiction. It was really helpful because what the court was, I think, really helpfully articulating was that states' obligations to regulate private actors and public actors and to ensure that they do not cause transboundary harm, including by greenhouse gases, it's not restricted to the territory of the state, and that jurisdiction and control, the concept of jurisdiction is wider than territory, and it draws on its rich jurisprudence to support that, as well as a jurisprudence from other international tribunals. This contrasts with the ICJ opinion, which takes a slightly more restrictive view by saying that the territorial scope of the human rights treaties must be assessed on a treaty-by-treaty basis, and does not try to articulate a more overarching principle for the territorial scope of these human rights obligations. Final point is that when we talk about the advisory opinions and how that, I think that it really helps to strengthen the journey of of making the links between human rights and climate change. And as you said in your introduction, Suya, the idea that climate change would adversely impact and is adversely impacting a whole range of human rights. But at the same time, the human rights legal system offers powerful tools for accountability and climate justice. So on that, I'll hand it back to you, Suya.
Thank you very much, Jolene. And in relation to your point about jurisdiction and territory, I think that becomes very critical in relation to climate change, because you cannot regulate climate change with the typical territorial regulatory approach. So I think thank you for highlighting it. Now we have several questions. One question is specifically to Justice Preston. So I will read the question for you, Justice Preston, and you may reflect a bit. And then there's another question which is perhaps maybe relevant for all of you. So I'll read first the question for Justice Preston specifically that came from Jasmine. And the question is that how do you envision the advisory opinion will shape climate litigation and related environmental right cases in Australian context? So I think that is like, how do you think this is going to have implications in terms of litigation in Australia? And there is a generic question, but I think it's a very critical question posed by Hussein. And I will request all the panelists to reflect on that question. And the question is that how this ICJ advisory opinion, which is not legally binding, technically speaking, is going to unfold before domestic courts. Let us say a climate activist takes a government. It could be Australia, it could be Fiji, it could be any government, to the court that you're not doing enough in line with the ICJ advisory opinion. And the developing country says, oh, we don't have enough resources, or we have not created this problem, so you're knocking at the wrong door. So how do you see this going to unfold in practice, and the complexity of dealing with lack of resources and you need technologies and all that? So who would like to start? Anyone can start. And you can be brief, and then we can have a dynamic discussion. Anyone wants to jump in to these questions?
I could start with a brief.
Okay, please. Yeah, go ahead.
I do think that the advisory opinion would kickstart some climate litigation, particularly at a more regional and international level. The Philippines, for example, has a corporate accountability bill. A climate accountability bill. Sorry, Freudian slip. Climate accountability bill that's pending in Congress, and a large part of that bill is on loss and damage and corporate accountability. And I do think that the advisory opinion provides some very interesting grounds for supporting some of the kind of cases that proponents behind this accountability bill are hoping to bring.
Thank you for that. Justice Preston, do you want to reflect on any of these questions?
Look, the particular one, I can't give a full answer in the time available, but I think these aspects need to be looked at. As would be expected, the Inter-American Court of Human Rights is particularly concerned with the human rights concerns, a point made by Jolene, while the ICJ is looking at it more generally. So it does deal with human rights, but it comes at adopts a different approach. But I think what, just staying with the Inter-American Court of Human Rights, its analysis of the rights also carries with it, as I've said, the correlated duties. And so it unpacks, and I'll deal in a later question, how it unpacks the right to a healthy environment, to include a right to a healthy climate. But it then says that those rights, both the generic right to a healthy environment and the specific right to a healthy climate, give rise to three specific obligations on states. The first is to take action to address the causes of climate change by mitigating greenhouse gases emissions. The second is to protect nature and its components. And the third is to adopt progressive measures to achieve sustainable development. Now, the court then unpacks each of those obligations. So it sets, it finds that the obligation to mitigate greenhouse gas emissions entails three duties for states, and that includes, regulating greenhouse gas emissions, monitoring and controlling achieving the mitigation target that they set, and thirdly, requiring and approving in environmental impact studies. And so those obligations may carry over into domestic law. Now, the second of the obligations concerning the protection of nature and its components, the court says it gives rise to 6 identifiable specific obligations and assess what those are. And finally, it explains what it means by the duty to adopt progressive measures towards sustainable development. So we can't directly take what the Inter-American Court of Human Rights says and just apply it into domestic law in Australia. We have to find what of the positive law in Australia we can interpret to include these obligations. So what it does is gives you let's say, an idea source, a library from which you can draw to say how these obligations that have been recognized by the Inter-American Court of Human Rights be found in the domestic law. And once you find that, that then provides the avenue for the domestic climate litigation. So I think that's, it would take me a lot longer to unpack all those obligations and find where we would find the counterpart within the domestic law. But that's the way you'd go about making it relevant to domestic law.
Thank you, Brian, for unpacking this. So basically what you're saying is that a potential litigant in Australia would need to find a hook under domestic law, and then rely on the ICJ advisory opinion or the Inter-American advisory opinion as a tool of interpretation, that what should those obligations may mean in the context of Australian legal context. I wonder whether, Joanna, you want to jump in, because I'm thinking once the celebrations are over, you would start thinking of next wave of litigation, because there is no way going back for the Pacific as far as I can see now, after the ICJ opinion. So how do you see this unfolding? And in fact, there is another anonymous participant asking a question that ICJ advisory opinion is mostly about the national level government, the federal government, let's say in the context of Australia. But we also have the provincial level governance and governments, right? So how do you go below the national level and go to the province, or go even further down? That's the city councils, right? What implications ICJ advisory opinion has for a city council anywhere, right?
Yeah.
So I wonder if you want to reflect on that. Thank you.
Yes, these are great questions. And again, gosh, we need to do several webinars where we can dig a lot deeper into this. But, following along from Professor Injustice, that, the advisory opinions and what we saw laid out really do provide quite a good blueprint of the types of litigation we need to see following from this, and how to really give, meaning and teeth in the domestic and lower courts areas of like how it is that we can find proper climate justice on all levels of the law and at all levels across the world. Like, obviously, given my role now and what a lot of us saw coming down the pipeline as we thought about the ICJ was really what to do about the fossil fuel industry and other extractive industries that have an outsized burden of impact on GHG emissions. And so obviously I was very excited when I read the infamous paragraph 427 that, failure of a state to put forward appropriate action to protect the climate system, whether it's from fossil fuel production, consumption, licensing, or subsidies, may constitute an internationally wrongful act. I think that is super, super key and a great hook to sort of what Jolene was talking about, and where we can see and move forward on corporate accountability, which will fall, as well as for states all the way down. And, I think I would flip that second part of the question on how it is that lower courts, we don't need to wait around to do things, especially at state levels, at municipal levels. We know it's going to have to be all hands on deck, everyone on board. We have until the end of this decade to turn things around. The science is clear, and the ICJAO sided with the science. And so it will be really interesting to see the breakdown between the federal, state, and local governments on how far we can push, whether it is something along the lines of when a state is going and putting forward licensures and oil things moving forward when we know that everything needs to be shut down, and where we can sort of fight back against that, especially given the language that the ICJ provided, or where even at the very, very local levels, you can push for greater climate ambitions, on the day-to-day basis of what it looks like in your own community. And I think, of course, the Pacific is a great example of how that community organizing can have impacts at an international level. And so if that can happen on an international level, it would be lovely to see what can happen around the world, local to state to federal.
Thank you. Thank you for elaborating these ideas, Joanna. And there was another question from Patricia, and she is asking a question about the role that these resolutions of General Assembly or Human Rights Council play in litigation like this, or the advisory opinion that we are discussing. Because sometimes many of us think that these resolutions of the Human Rights Council, because it started in the Human Rights Council in 22, and then General Assembly adopted this resolution on recognizing right to a clean, healthy, and sustainable environment. And sometimes we think, oh, these are just pieces of paper. They don't add any value. But I think these two advisory opinions show that sometimes these resolutions can be a very solid foundation for building this jurisprudence. So I think, thank you, Patricia, for asking that question. One thing that we have not covered yet, Carlos, is the role of environmental human rights defenders and the climate activists, right? And I think the ICJ did not go deeper into it, but the Inter-American Court again devoted a lot of attention to environmental human rights defenders. So Carlos, if you can briefly highlight the importance of that aspect of the advisory opinion, because at times, many of these defenders are facing a very constrained environment. They're facing pressure from both businesses and the governments. So your reactions on that. Thank you.
Yes, thank you so much, Surya. Before I answer this question, if I may add a small point concerning the former question.
Go for
from
it. Yeah. Thank
you. Latin American point of view is that in many countries of Latin America, even Colombia, in which I serve, where I serve as a justice of the Colombia Constitutional Court before, we have a notion that is called the constitutional block. And what is that idea of the constitutional block? Is that we acknowledge that the constitutional rights are not only the fundamental rights that are entrenched in the Constitution, but in addition, we need to add all the human rights that are based on treaties that Colombia or Brazil or Peru or Costa Rica, because it's the same doctrine in those countries, have ratified, plus the interpretation of those rights by committees and agencies, even rapporteurs. I have passed to some activists in my countries, for instance, some of the reports by Surya, and if the court cites you, I will let you know, Surya. But in particular, I would say the Constitutional Court is very likely that in the future quotes directly the advisory opinion of the ICJ or the advisory opinion of the Inter-American Court of Human Rights. And the same thing can happen in Brazil, Costa Rica, Peru, Ecuador, all those countries. Now, concerning the point of defenders of climate and rights of environmental human rights defender, why is this a crucial point in the advisory opinion of the Inter-American Court of Human Rights? The first, which is a very sad point, is that there is a long history in Latin America of violation of the rights of environmental human rights defenders. There is a critical case that we had at the Commission, which is the case Berta Cáceres versus Honduras, which is about the murder of an activist who tried to prevent some mining projects in an area that is environmentally rich, and was murdered for that. And this is one of the most important cases of the commission. So there is that history of violation of human rights. Now, there is a second point that in the year 2018, within the Inter-American system, the Treaty of Escazú was signed, and right now it's in the process of ratification by many countries. And Article 9 of that treaty secures all the rights of the environmental defenders for this historical reason and contextual reason. So building on the Escazú rights, the advisory opinion talks about, in paragraph 563, talks about the special duty to protect rights of environmental defenders in the context of the climate emergency against states and private measures and companies. And I would like to highlight 2 points here. The first point is the particular protection that women journalists and vulnerable environmental defenders deserve, and the court highlights those rights in a very important way. And then the court talks about two matters that are quite key in the continent, namely the harassment against them and also the criminalization. Why is that? Because in many countries, there are criminal laws that says, for instance, if you are a human rights defender and you are making a protest in front of a project, and for the reason the project is disturbed by 1 day, then you can be criminalized. This is a criminal offense. So the court talks about that and says that this cannot be a way to create persecution against the environmental and climate defenders.
Thank you, Carlos. There are very interesting questions coming both in the chat as well as in Q&A, and unfortunately, we will not be able to capture everything. But there will be subsequent opportunities. In fact, the center is going to organize a major international conference in March next year, where we will dive deeper for 2 days in some of the issues. So details to come very shortly. But let me pick up a couple of issues. There is a comment and a question from Diva for Equality, and talking about that how these advisory opinions will help communities on the ground in terms of loss and damage, for instance, right? Because at the end of the day, ultimately the question will be who will pay for the loss and damage? Who will pay for adaptation? Who will pay for mitigation, right? Are developed countries going to make those payments? I think that is going to be a crucial question. So how this is going to unfold in terms of dollars. And maybe, Jolene, because you recently published this book, Litigating Climate Change in the Global South. So how do you anticipate that things may unfold differently going forward because of these advisory opinions in some of tangible outcomes on the ground for the communities which are impacted? And I think that's where the terminology of emergency resonates very well with these communities. It's not merely climate change, it is climate emergency, right? So if it is an emergency, you don't go to a normal GP, right? You go to the emergency section of the hospital, right? So I think, so your reflections on that. And maybe I will come to Justice Preston then, because there are questions about how the courts in Australia have been interpreting, and especially the more recent decision in Torres Strait Island case, and whether that decision should have been different if ICJ advisory opinion came before. So maybe, Mr. Preston, you may reflect a bit on that after Jolene. Thank you.
Thank you, Surya. So I would say that one of the most significant aspects of the AO that will have quite a lot of relevance for ongoing and future climate litigation, particularly related to loss and damage, will be the court's pronouncements on attribution and causation. So for the first, when the court articulates very clearly that it's not buying the argument that because every state is both a polluter as well as a victim of climate change, there can be no accountability and responsibility. And basically, the court actually says that each injured state may separately invoke the responsibility of every state which has committed an internationally wrongful act and resulting in damage to the climate system. And where several states are responsible for the same internationally wrongful act, the responsibility of each state may be evoked in relation to that act. I think that's a very important pronouncement by the court in the advisory opinion, the ICJ advisory opinion, because for a long time, even in domestic jurisprudence, there's always the familiar argument by defendants that, well, it's a drop in the ocean. That's one argument. The other is that because everyone is responsible for climate change, therefore no one is responsible for climate change. And the court says, nah, no. Even just invoking the traditional concepts of state responsibility. And this is where it's also really useful because the court goes back to traditional doctrine of state responsibility and says, we don't need new laws or new interpretations that much. We actually have the tools on hand to hold states responsible for climate change harm. And on causation, that's really interesting because the court actually stands for climate science and says, when you talk about causation, you have two issues there. One is about whether the event is attributable to climate change. And it says, well, the answers are there. The IPCC and the scientists are telling us there is enough climate science to tell us the answer. As to creating the causal link between the damage and the group of states or the state, the court says, well, we actually can, the identification of the causal link with using traditional state responsibility law, we can achieve that, we can do that. So I think the court is actually setting out quite a bit of clarity to that will really bolster, I think, the litigation, well, I guess basically the case theories that can be brought. And over to you, Justice Preston. I hope I didn't take too long.
Thank you, Jillian. Yeah. Brian, over to you.
So the question is whether there's a recent case which has been decided in Australia, Pabai and Cabai, against the Commonwealth of Australia, and that was unsuccessful. What that case was doing was challenging the federal government, Australian federal government's action and inaction in relation to climate change, and they were trying to have the court recognise that there was a duty of care in various ways owed by the Australian government to the Torres Strait Islander people. Now, I think the first thing we need to recognise is that the three advisory opinions, including the latest by the Inter-American Court of Human Rights and the International Court of Justice, are dealing with state obligations at an international level. And although they are dealing with obligations, they are primarily concerning with those duties that arise. And that's, of course, what the reference was and what those state obligations were. Now, the Pabai case was concerned with domestic state obligations. And so the question was there an obligation upon the Commonwealth government in various ways? Now, one way they said it arose was under a domestic environmental legislation called the Environment Protection and Biodiversity Conservation Act, where the federal government was exercising statutory powers, and there was a discretion as to how they exercise those powers. So the question arose with whether a common law duty of care attached to the exercise of those statutory powers. Now, there's a line of authority which says sometimes it can, but equally there's a line of authority which says other times it won't. It will depend upon a matter of statutory construction of the particular statute. Now, the court held in this case and an earlier case of Sharma, that the duty of care did not arise and attach to the exercise of those statutory powers. Now, that's domestic law. And so the international obligations on states found by the ICJ and the Inter-American Court of Human Rights will not directly apply and wouldn't have directly made a difference to those decisions in the Australia's courts. However, that's not to say that those international obligations on states cannot influence a court's understanding of whether there is a duty and what is the content of the duty on states at the domestic level. And I'll give an example of the agenda case. So there the case was primarily brought under the, two grounds, one under the European Court of Human Rights for breaches of Articles 2 and 8, and the second was under the Dutch Civil Code for essentially negligence, so that there was a duty of care owed in hazardous negligence. Now, at first instance, the Hague District Court dismissed the claim based on human rights, but upheld the claim based upon the Dutch Civil Code, the duty of care. On appeal in the Hague Court of Appeal and in the further appeal in the Supreme Court of the Netherlands, they upheld the claims under the European Convention on Human Rights. But at first instance, and affirmed on appeal, it was said that the content of the duty of care can be informed by the obligations of the state under the European Convention on Human Rights. So there was an influence of those international obligations owed under the European Convention on Human Rights in determining what the content of the duty of care was. So come back to the Pabai case and the Sharma case, it's possible that, although not directly applicable, what the courts have found is the obligations of states could inform finding whether there is a duty of care at a domestic level, or more particularly what the content of that duty of care is. And so I think that's the way it could have an influence. But of course, it all depends upon the judge and the court and its preparedness to have regard to international law where it has not been directly incorporated into domestic law.
Thank you very much for this very nuanced analysis of how these advisory opinions may impact the jurisprudence and the domestic law. Thank you very much. Participants, we don't have enough time. Unfortunately, they're very interesting questions. And as I mentioned, we will have the follow-up conversations virtually or in person because the jurisprudence of these two advisory opinions, or all three, in fact, is very rich. And it will take many years and decades potentially to see how they are shaping the law and policy discourse. There was also a comment about the ASEAN adopting a declaration on the right to a safe, clean, healthy, and sustainable environment. So all these implications will be interconnected. But now let me give the floor to Heike. Thank you, Heike, for your patience. And thank you also for joining hands with the Center for co-organizing this event. I would like to give you the floor for providing some closing remarks. Thank you. You have the floor.
Thank you very much, Surya and Bulavinaka from Fiji. First of all, I'd like to thank everyone, the distinguished panelists and the participants for being part of this very important and timely discussion. And very many thanks to Surya Deva for the partnership and for your excellent moderation of this event. Without trying to summarize the main points that emerged from this discussion, I'd like to highlight a few issues. First of all, that these landmark advisory opinions by the International Court of Justice and the Inter-American Court of Human Rights represent really more than legal milestones, and they are of interest to a very large number of people. Because they are, in fact, a reflection of the growing recognition globally, not just in the climate justice discourse space, that climate change is not only an environmental or economic issue, but it's fundamentally a human rights issue. And it affects us all. So as all of the panelists have underscored, the impacts of climate change threaten a wide range of human rights, the right to life, health, water, food, self-determination, you name it. And of course, increasingly recognized, as we've also seen in some of the questions that have come out in the discussion, the right to a clean, healthy, and sustainable environment. But very critically, these harms are not distributed equally, because climate change actually deepens inequalities and it places dignity out of reach for many people. So those who are already vulnerable, women, older persons, persons with disabilities, indigenous peoples, children, persons of diverse sexual orientation, gender identity and expression, or LGBTIQ plus individuals, and those living in remote or rural areas, of which we have very many here around the Pacific, they're often the most affected. And that is why these opinions, especially the ICJ opinion, of course, is so important for us here in the Pacific. So in many ways, they help to reframe our global climate response through a human rights lens, and they place people, and especially those at the margins, at the center of our attention, which is very key. Because we are also living at a time when multilateral justice and international institutions are increasingly being challenged. And I think it is a great achievement of this advisory opinion that it really has led to greater interest and also greater affirmation of the importance of these international justice institutions. So the opinions are, however, not only about legal obligations, because as one of our other panelists also said, and several of the questions also actually touch upon this, they're also about inspiration, because really they remind us of the powerful leadership that we've seen of small islands developing states in shaping the global climate agenda. And in particular, I'd like to shout out to Vanuatu, one of the countries that, along with others from the Pacific and other countries, which is one of the most ravaged by the impacts of climate change here in the region and globally, has taken up the cause. And so it's a story of courage, of persistence, and of vision, of course. And also, it's a story of youth. And the role that the students played, as some of you have said, we could have an entire webinar probably about that role. And we know that there's a film being made about that has been made about them, and many other opportunities that they might perhaps have to give us their perspective, perhaps in another webinar. So the role that these students played in initiating and driving this process is a very powerful reminder also that young people are not simply the leaders of tomorrow, but they are also the change makers of today. And what was particularly encouraging for us was to see the powerful testimonies that we've seen in the public hearings that I'm sure many of those online have also watched, especially of the young women climate activists who are at the same time also human rights defenders. So this achievement is a testament to what is possible when citizen action and political will come together. And lastly, I would like to say that our office, the UN Human Rights Office globally, but also in the Pacific, we're happy to have contributed in a small way to these important efforts because we've made submissions to the Office of Legal Affairs, which represented the UN Secretariat in the UN in this case, and we've submitted relevant OHCHR reports, and also, of course, the work of human rights special procedures and treaty bodies. And over the past few years, we've been working to enhance the voices of young climate activists, environmental human rights defenders in the Pacific, and we will gladly continue to do so. But finally, I would like to look forward and to say that we now have to shift Again, that was mentioned earlier, from legal advice to implementation. So we hope that these opinions will serve as a springboard for greater international cooperation, stronger climate ambition, including by countries here in the region, by states, by businesses, especially as we approach COP30 and 31 and other key negotiation moments. And these opinions, we think, also must have a national impact. There's been a discussion about litigation, again, probably food for another webinar. And there must be impact and open avenues for individuals and communities who are already affected by climate change to seek justice and to build resilience and access remedies for loss and damage. This requires a collective response, and governments must act, but they're not alone. Academia, civil society, environmental human rights defenders, climate activists, youth, private sector, United Nations, Pacific Islands Forum, Pacific Community, regional organizations, we all must work together to amplify Pacific voices and to forge solidarity and advance a regional vision of climate justice that is rooted in human rights. So we believe quite strongly that real progress will come from listening to the communities and to working across movements and standing in solidarity. And again, as I said earlier, I believe this is especially important at this point when human rights are under attack globally, when the concept of human rights is basically being challenged. And so this is why it's so important to have these advisory opinions. We stand ready to work with all of you, and today's conversation is really part of a growing call for climate action that's grounded in justice and inclusion and in human rights. Thank you very much, Surya, and everyone.
Thank you very much, Heike. And let me also thank all the panelists. We have had panelists joining from the US, from Singapore, from Fiji, and of course in Australia. So it has been a global conversation. And I think the time now going forward is to take these advisory opinions from paper to practice, and how we can work together to achieve not, I would say, climate justice, because climate justice as a term is a powerful reminder what needs to happen and the inequalities that Heike you alluded to between countries as well as within countries. So thank you everyone for joining this. Also all the participants for your active engagement. My apologies, I could not capture all the questions, but I did my best in the limited time, but there'll be more to come. Thank you everyone. Take care, have a good time, and we continue to work collectively.